Good evening, and on a Sunday evening, I think there couldn't be a much pleasure those who are always associated with the knowledge sharing when Mr. S.R. Somasekhara intends to share his knowledge and his passion to take different issues of law and the wide spectrum of knowledge is a testimony on different occasions he has already taken on different perspectives of law. Today's session, especially for the practitioners and on the judicial side, the judges, and the very fact that a lot of judges from the trial courts are participating is also the factum that Mr. S.R. Somasekhara is so popular, where he makes things so simplified. Today's topic, proof and importance of the documentary evidence in civil cases, is another, I can say, that feather in his cap where he shares his knowledge with us, and we are quite sure that as usual, it will be quite simplified and well accepted within the masses. Over to you, sir.
Good evening, Vikas Chatat, and good evening, friends. At the outset, I'm thank Vikas Chatat for special office and first, let us not presume anything. Though the Evidence Act provides for certain commencing from section 101 and ending with 167. Of course, section 1, as usual, extent applicable. Simply go by the language of section 61. It gives an indication that a document may be proved either by original documents, I mean, contents of a document may be proved either by primary evidence or by secondary evidence. Let us immediately go to section 64. Before going to 62 and 63, let us go to 64. Documents must be proved by primary evidence except in the case hereinafter mentioned. So therefore, though section 61 says that documents may be proved either by primary or by secondary evidence, as per section 64, they can be proved by secondary evidence only in the situations mentioned in the Act. Which are those situations? A big list is given in sections, in clauses A to G of section 65. I personally feel that section 62 should have been in the beginning, explaining what primary evidence is. Then 63 should have been the next section in that scheme, telling what secondary evidence. Then 61 and 64 could have been clubbed in one section, making it a main part, section 61 main part, what is contained in section 64 being its proviso. You would have understood the provisions clearly. Be that as it may. As I said, section 65 gives situations in which secondary evidence could be let in. I'm not going to read the whole of them. What usually happens in the court is when the original is lost or destroyed, or when the original is in the custody of the opponent, or when the original is admitted to be in writing. These are situations where secondary evidence is letting. I do not know the position elsewhere in the country. In some parts of Karnataka, the bar is in the habit of making an application under Section 65 of the Evidence Act, seeking permission of the court to let in secondary evidence. An honorable judge of the Karnataka High Court has held that no such application is required for letting in secondary evidence. Foundation for letting in secondary evidence should be laid in the witness parts. If it is the plaintiff or the defendant who wants to let in secondary evidence, he must enter the witness parts and state as to what has happened to the original. This is the legal position. Maybe high courts of other states also have taken a similar view. Whatever it is, at least for the benefit of advocates and judicial officers in Karnataka, most of them know this decision, but let me also refresh their memory in drawing their attention to a judgment of Honorable Justice N. Kumar in Ghaffar Saab versus Amir Ahmad. Ghaffar Saab versus Amir Ahmad, ILR 2006, Karnataka 169. ILR 2006, Karnataka 169. It has been made clear that no application is required under Section 65. Plaintiff or the defendant who intends to lead in secondary evidence has to enter the witness box and state as to what has happened to the original. Now the problem is this. After Civil Procedure Code came to be amended in 1999/2002, affidavits are filed in lieu of chief examination. Affidavits are again a reiteration of the pleadings. So therefore, if in the pleadings it is not stated where the original is or where the originals are, obviously we do not find it in the affidavits. Therefore, when a lawyer tries to mark a copy of a document or let in secondary evidence, the opponent advocate should say it is secondary evidence, and the lawyer who is intending to mark it at least should get it explained through his client. When these documents are marked as to what has happened to the original, judicial officers also will do well to see if the affidavit does not say as to where the original is, as to why the original could not be produced, then the court at least should intervene before marking the copies as to what has happened to the original. If it is stated in the chief examination that the original cannot be produced for any of the reasons stated in clauses A to G, foundation is laid. Whether what the plaintiff or the defendant has said about the availability or non-availability of the original is true or false is a different aspect of the matter. He makes a statement on oath that he is not able to produce the original for this particular reason. It will be for the opponent to bring out in the cross-examination as to show to the court that he is deliberately suppressing the original for some reason. Well, that could be effective. He could be effectively cross-examined, and ultimately the opponent may convince the court that the original is available in the plaintiff or the defendant. For some reason, he has not produced it deliberately. That is ultimately a matter for appreciation of evidence. This is one thing. Of course, some judicial officers often have asked me that in the plaint or the written statement itself, it is not explained as to where the original is. To me, it appears if it is a suit document, that is a document on which the plaintiff relies upon to establish his case, or if it is a defense document, a document on which the defendant mainly relies upon to establish his defense, well, better to state it in the plaint or the written statement as to where the original is, why it cannot be produced. But there may be other documents. They are not documents, they are documents on which the plaintiff or the defendant relies upon to prove a particular issue cast on him. That they may not be the main documents. I think in respect of those documents, at least when he enters the witness box, if he is able to say as to why he is not able to produce the original, the court can accept it, mark it. Of course, as I said, it will be for the opponent to cross-examine effectively and point out to the court that deliberately that person has suppressed the original. This is with regard to letting in secondary evidence. Now, a problem arises. In the cross-examination, a copy of a document is shown either to the plaintiff or to the defendant or a particular witness. He admits it. Would it be marked in cross-examination is the question. I am of the firm opinion that foundation for letting in secondary evidence is only as far as marking a document in the chief examination is concerned. If in the cross-examination, a document is confronted to the plaintiff or to the defendant or to a witness, he or she admits it, there is absolutely no difficulty in marking that document. Of course, the signature cannot be marked because you don't find it. There will be a good number of situations where the opponent who cross-examines a plaintiff or a defendant will not be in the possession of the original at all. It may be elsewhere. Plaintiff sues for a particular relief. He has executed a document in favor of a person, not a party to the suit. The original is with that person who is not a party to the suit. He is not bound to give it to the defendant. Well, whether he could be summoned to the court is a different aspect of the matter. Defendant by some means has a copy of it. What prevents him from confronting it to the plaintiff? Same thing it applies to the plaintiff's counsel when he cross-examines the defendant. I was very clear about this, and now I am also fortified in this view by a judgment of the Supreme Court in 2015, Volume 1 SCC 705. 2015, Volume 1 SCC 705, Zarina Siddiqui versus Ramalingam. Zarina Siddiqui versus Ramalingam. What happened in this case was the original power of attorney on which one of the parties to the suit was relying upon was not produced. That original power of attorney was not a power of attorney for him to conduct the case. In respect of some transaction, one of the parties to the suit had given a power of attorney to the other. That original power of attorney was not produced to the court. The party who had executed the power of attorney had taken a contention that it gave limited powers to the other side. It did not authorize him to do anything beyond that. The person holding the power of attorney contended that it was an unlimited power of attorney. He had several other powers thereunder. Neither of them produced the original. A photostat copy was confronted to one of them in the cross-examination. He admitted, and therefore it was marked. In fact, it is a case from the Karnataka High Court. When the matter reached the High Court took the view that original was not produced and an adverse inference had to be drawn. When the matter again reached the Supreme Court said there is no question of drawing any adverse inference when the original was not produced and when the opponent admitted in the cross-examination the execution of the copy of that, the original of that document, when the copy was confronted, there is nothing wrong in relying upon it. The observations and the law laid down in this regard could be seen at para 22 of the judgment in the case. I must also put a word of caution. Between the same parties, we have another judgment, Siddiqui versus Ramalingam, reported in 2011 for SCC 240. 2011 for SCC 240. It was decided on 4/3/2001. The matter was remanded to the High Court. After remand, the judgment was passed on 29/10/2014. It is the judgment passed on 29/10/2014, which is reported in 2015 1 SCC 705. So those of you who go only by the names of the parties may tend to lay their hands on 2011 4 SEC 240 and they may find something contrary to what I have said. So therefore, please go through the decision reported in 2005 1 SEC 705. Now, one other question would arise. At the time when a copy is sought to be marked, no objections are raised by the opponent or by the court. The document gets marked. I want to make it clear, I am not speaking of a document which requires compulsory registration under the Registration Act or under the Transfer of Property Act, nor I am speaking about a document which requires to be stamped and it is either not stamped or insufficiently stamped. There are two special separate enactments in that regard. I am not speaking about them today. Let me not bring it here. I am only speaking of a situation where a document, a copy of a document is tendered in evidence and that has been marked without any objection either by the court or by the opponent. Could it be raised later? I am again repeating, I am not referring to section 35 of the Karnataka Stamp Act or section 36 of the Indian Stamp Act, which says that when once a document is marked, the court which has marked it cannot review its order. Certainly, I am not on section 35 or 36 of the Karnataka Stamp Act or the Indian Stamp Act, because I see some young judicial officers on the video, they may mistake this for section 35 of the Karnataka Stamp Act or 36 of the Indian Stamp Act. I am making it clear I am not on that point. And neither I am on the point about the admissibility of unregistered documents. I have had enough say about it on earlier occasions. I am on a different aspect of the matter. Foundation is not laid as required under section 65. A copy of a document gets marked without any objection either by the court or by the opponent. Can that be later questioned? This matter has been considered by the Supreme Court very elaborately in 2003, 8 SCC 752. 2003, 8 SCC 752. I am avoiding the names of the parties because it takes a good lot of time. And as usual, I am repeating the citations. 2003, 8 SCC 752. This judgment has been subsequently followed. Refer in 2004, 7 SCC 107. 2004, 7 SCC 107. In this 2003, 8 SCC 752, the relevant paras are at the paras 19 and 20. But to understand what exactly was the document which was marked without any objection, rather, which were the documents which were marked without any objection, you may also read paras 12 and 14, 16, etc. What ultimately the Honorable Supreme Court has held in this decision is, there are two kinds of objections. Objections which go to the root of the matter, like a document being not stamped or insufficiently stamped, or if the provisions of the Stamp Act would come there. Documents which are not registered, but which are compulsorily to be registered. There is a total bar for admitting such documents under the relevant statutes. But this is a different situation. In cases of this kind, where the document is marked without any objection, it would not be open to the court or the other side to contend that the document could not have been admitted in evidence. I only read one or two sentences in this case. I am reading para 20 of the judgment, available at page 764. The learned counsel for the defendant respondent has relied on some decision in support of his submission that a document not admissible in evidence, though brought on record, has to be excluded from consideration. We do not have any dispute with the proposition of law so laid out in the aforesaid case. However, the present one is a case which calls for the correct position of law being made precise. ordinarily, kindly hear me, ordinarily, an objection to the admissibility of evidence should be taken when it is tendered and not subsequently. The objections as to admissibility of documents in evidence will be classified into two classes. An objection that the document which is sought to be proved is itself inadmissible in evidence, and where the objection does not dispute the admissibility of the document in evidence, but is directed towards the mode of proof of alleging the same to be irregular or insufficient. In the first case, that is a case where the document is totally inadmissible in evidence, merely because a document has been marked as an exhibit. An objection as to its admissibility is not excluded and is available to be raised even at a later stage or even in an appeal revision. In the latter case, the objection should be taken when the evidence is tender and when once the document has been admitted in evidence and marked as an exhibit, the objection that it should not have been admitted in evidence or that the mode adopted for proving the document is irregular cannot be allowed to be raised at any stage subsequent to the marking of the document as an exhibit. The latter proposition is a rule of fair play. The crucial test is where an objection, if taken at the appropriate point of time, would have enabled the party tendering the evidence to cure the defect and resort to such mode of proof as would be regular. The omission to object becomes fatal because by his failure, the party entitled to object allows the party tendering the evidence to act on an assumption that the opposite party is not serious about the mode of proof. On the other hand, a prompt objection does not prejudice the party tendering the evidence for two reasons. Firstly, it enables the court to apply its mind and pronounce its decision on the question of admissibility then and there. And secondly, in the event of finding of the court on the mode of proof sought to be adopted going against the party tendering the evidence, the opportunity of seeking indulgence of the court for permitting a regular mode or method of proof and thereby removing the objection raised by the opposite party is available to the party leading the evidence. Such practice and procedure is fair to both the parties. Out of the two types of objections referred to here in above, in the latter case, failure to raise a prompt and timely objection amounts to waiver of the necessity for insisting on formal proof of the document itself which is sought to be proved being admissible in evidence. In the first case, admissibility would be no bar to raising the objection in a superior court. Of course, that is subject to section 35 of the 35 of the Karnataka Stamp Act corresponding to section 36 of the Indian Stamp Act. And then one provision in section clause 6, section 65 is required. That I will tell you. Please go to clause A. When the original is shown or appears to be in the possession or power of the person against whom the document is sought to be proved, or of any person out of reach of, or not subject to the process of the court, or of any person legally bound to produce it, and when after the notice mentioned in section 66, such person does not produce it. A mortgager files a suit for redemption. Obviously, the original mortgage deed is the mortgagee, the defendant. The mortgager, the plaintiff, cannot be expected to produce the original. The original is the mortgagee. Of course, if the mortgagee does not dispute the execution of the mortgage, there is no need for the plaintiff to call upon the mortgagee to produce the original. Supposing he disputes that there is such thing at all, then he has to formally issue a notice as provided under section 66. The format is in order 12 CPC. Call upon the defendant to produce the original. The defendant may say that there is no such deed, or defendant may say, I have myself lost it. He may take some reason, whether it is true or not is a different aspect of the matter, that entitles the plaintiff mortgager to get the document marked. How that notice has to be issued is stated in section 66. Supposing a legal notice is issued prior to the filing of the suit, or a statutory notice as required under section 80 CPC is issued. Obviously, the original is with the defendant. Plaintiff has only a copy of it. Normally, no objection is raised for marking the lawyer's copy retained by the lawyer in his office. It is not marked. Supposing the receipt of the original itself is disputed, the plaintiff may call upon him to produce the original. He says, I have not received it at all. Then it would entitle. And in fact, 66 says If the document to be marked as a notice itself, then there is no need to issue notice under section 66 of the Evidence Act. 66 itself says it. And the other situation is when the original is lost, destroyed. In all these cases, original secondary evidence could be let in. Now, with regard to the proof of execution of a document, we shall spend some good time. We'll start from section 67. If a document is alleged to be signed or to have written wholly or in part by any person, the signature or the handwriting of so much of the document as is alleged to be in that person's handwriting must be proved to be in his handwriting. It is as simple as this. If the signature is disputed or the handwriting of the person is disputed, the person who has produced that document has to prove that it is the signature of the opponent, that it is in the handwriting of the opponent. 67A, proof as to electronic signature, you will have experts who speak about it. I am not accomplished enough to speak on that. Let me go to section 68. Proof of execution of document are not required by law to be attested. If a document is required by law to be attested, it shall not be used as evidence until one attesting witness at least has been called for the purpose of proving its execution, if there be an attesting witness alive and subject to the process of the court and capable of giving evidence. Please read each of these things very carefully. If a document is required by law to be attested, so the first condition required for the applicability of section 68 is, in law, a particular document requires attestation. Then it can be used only if one attesting witness at least has been called for the purpose of proving its execution. At least one attesting witness has to be examined. When? If there be an attesting witness alive. If he is not alive, or both of them are not alive, where is the question of examining them? And subject to the process of the court and capable of giving evidence. Some of me have heard on number of occasions. I always say 3 A's. A person must be alive, a person must be able, a person must be available to give evidence. 3 A's. If he is alive, but he is not available, he is absconding. He is alive, he is available, but not able, physically disabled, mentally disabled. So for a person to come and give evidence, these 3 A's, alive, available, and able. You will see those 2 vowels E and 1 consonant L in all these 3 words. Able, alive, able, and available. Please remember this. If he is not alive, or if he is not able, or if he is not alive, what is to be done, we will go there. But the proviso is important for this. Provided that it shall not be necessary to call an attesting witness in proof of the execution of any document, not being a will, which has been registered in accordance with the provisions of the Indian Registration Act, unless its execution by the person by whom it purports to have been executed is specifically denied. This is important for us. Now we know that 3 documents require attestation. Mortgage and gift under the provisions of the Transfer of Property Act and will under the provisions of the Indian Succession Act require attestation, compulsory attestation by 2 witnesses. These 3 documents can be proved only by examining one of the attesting witnesses if alive. Proviso is important there. Provided that it shall not be necessary to call an attesting witness in proof of the execution of any document not being a will. So if it is not a will, if it is a mortgage deed or a gift deed, then does examination of the attesting witness become necessary when its execution by the person by whom it purports to have been executed is specifically denied. Some time back, I have also explained this in a different context. Let me again do it today. Please carefully follow me. Plaintiff files a suit for declaration of title on the basis of a gift deed executed by one X, not the defendant. X is not a party to the suit. X is not a party to the suit. Plaintiff relies upon a gift deed executed by X in favor of the plaintiff. Defendant denies the execution of the gift deed. See the proviso. It shall not be necessary to call an attesting witness in proof of the execution of any document not being a will, unless its execution by the person by whom it purports to have been executed is specifically denied. Who is that person who has denied its execution? It is the defendant. Supposing that X, the donor, enters the witness box and supports the plaintiff and says, I have executed this gift deed in favor of the plaintiff, where is any need for the plaintiff to examine the attesting witness? Now, as lawyers, you rely upon a gift deed. Or for a judicial officer, a gift deed is before him or her. The plaintiff lawyer relies upon it. The defendant lawyer says, well, the gift is a document which requires compulsory attestation. My learned friend has not examined any attesting witness. But he has examined the donor who supports the plaintiff and says that he or she has executed the document. When does the proviso to section 68 apply? When the person who is purported to have executed it, that to deny specifically, there must be a specific detail in the document. On the other hand, if that X, the person who is purported to have executed the gift deed in favor of the plaintiff, denies execution, turns hostile, or he or she gives evidence in favor of the defendant saying, I have not executed any document, then certainly the plaintiff is bound to examine the attesting witness. So please remember this. And in the case of will, there is an exception. Will, whether admitted or denied, it has to be necessarily proved by examining one attesting witness. And all of you are aware of that famous decision in Timma Jamma versus Ventatarayangar, AR 1959 Supreme Court, page you please check up. All subsequent ratio laid down in all subsequent decisions is a reiteration of the ratio laid down in this famous decision. Timma Jamma versus Ventatarayangar in AR 1959 Supreme Court, page you will check up. Let us be very clear about this. Let us take a different situation. In the first example, I said plaintiff sues for declaration of title on the basis of a gift deed executed by X, who is not a party to the suit. Second is a situation where the plaintiff relies upon a gift deed executed by the defendant himself or herself, according to him. The defendant specifically denies his execution. In such an event, plaintiff runs the risk of not examining the attesting witness. He has to necessarily examine the attesting witness. 69. If no such attesting witness can be found, or the document purports to have been executed in the United Kingdom, it must be proved that the attestation of one attesting witness at least is in his handwriting, and that the signature of the person executing the document is in the handwriting of that person. This is important for us. Now, in respect of a document which requires compulsory attestation, what is it that the party relying upon that document has to establish? He has to establish that it is duly attested. Otherwise, the document is an invalid document. And then he is also required to establish its execution by the person who has executed. In the case of will, by the testator. In the case of gift and mortgage, by the executed. Supposing the attesting witness is not found, cannot be found, either on account of his death, or on account of his inability, or on account of his non-availability, he is not able to be examined. Then what is it that the party relying upon that document which requires compulsory attestation required to do? He must prove that the attestation of one attesting witness at least is in his handwriting, and that the signature of the person executing the document is in the handwriting of that person. It is here the mistakes happen. When the attesting witness is dead or for any reason he cannot be found, what is it in most of the courts happening? Some person acquainted with the signature of the attesting witness is examined, his son, daughter, Actually, somebody is examined. Let us take it, he also withstands the test of cross-examination. The court finds absolutely no doubt in accepting that the signature is of that particular attesting witness and he has identified it. But what is proved by that? What is proved is that the document is duly attested. We are forgetting the second part. It must also be established that the signature of the person executing the document is in the handwriting of that person. The framers of the Evidence Act left it there. They left it to the wisdom of the lawyers and the judges to see whether the signature of the person executing the document is in handwriting. The framers stopped there. Now, after section 68, in fact, according to me, before 69, 70, and 71, it should have been 72. Proof of document not required by law to be attested. An attested document not required by law to be attested may be proved as if it was unattested. So 72 should have been immediately after 68 to understand it correctly. An attested document not required by law to be attested may be proved as if it was unattested. Well, there may be some document which is admitted, signatures available in the courts to be compared, expert evidence to be secured, by other means, that document can be proved. A document which does not require attestation. Then go to section 70. The admission of a party to an attested document of its execution by himself. The admission of a party to an attested document of its execution by himself shall be sufficient proof of its execution as against him, though it be a document required by law to be attested. I already gave this example. A person seeks declaration of his title on the basis of a gift deed executed by X, not a party to the suit. That X, who is the person who is said to have executed the document, says, well, I have executed this document, therefore that will. So the admission of that person as to its execution is sufficient proof of its execution without examining the attesting witness. 71 is important both for judicial officers and lawyers. If the attesting witness denies or does not recollect the execution of the document, its execution may be proved by other evidence. Here, the framers of the Evidence Act did not commit themselves as to what that other evidence. As I said, they have left it to the wisdom of the lawyers and the judges. Lawyers, as to what other evidence they can let in. When the attesting witness denies or does not recollect, they will have to decide. And judges have to decide whether that evidence which is placed by the parties will prove the execution and will prove the attestation. What is this? If the attesting witness denies or does not recollect the execution of the document. Well, as I said, after the CPC came to be amended, examination in chief is now by way of affidavit. And obviously, he who supports the plaintiff or the defendant, he alone goes to the lawyer's office and he files an affidavit saying that I have attested this document. The executant signed in my presence or put his or her thumb mark in my presence. Supposing the attesting witness is not willing to oblige the plaintiff or the defendant, well, he will not turn up. Maybe the court is required to issue summons. In such a situation, we can't even insist on an affidavit. A departure has to be made. Examination in chief has to be conducted by the court itself. Well, he denies, no, I have not attested this document. Or he may say he does not recollect it. In such an event, well, provisions of section 154 of the Evidence Act, which enables a party to cross-examine one's own witness, will have to be invoked. Some of the juniors may be under the impression that 154 of the Evidence Act is applicable only to a criminal case where the witnesses, as I say, they do not turn hostile, they are made to turn hostile. That is the situation, unfortunately. But in most of the civil cases, witnesses do support the plaintiff or the defendant who has called them. But in a rare case where the witness summoned does not support the plaintiff or the defendant, recourse can be taken to section 154 of the Evidence Act. Request the court, I have summoned him to speak to attestation. He says that he does not recollect it, he denies it. No other way of proving it. Please permit me to cross-examine. Well, it has to be permitted. Then 73. In order to ascertain whether a signature, writing, or seal is that the person by whom it purports to have been written or made by any signature, writing, or seal admitted or proved to the satisfaction of that court to have been written or made by that person may be compared with the one which is to be proved, although that signature, writing, or seal has not been produced or proved for any other purpose. This is a practice which goes on into court. Well, the papers which are signed by the plaintiff or the defendant, like affidavit, signature in the deposition, written statement, wakalat, they are all confronted. Of course, in the usual course, just as the accused, when examined under 313, denies everything, well, the lawyer would have instructed him to deny everything. So he even goes to the extent of denying his signature and the written statement, wakalat. We have seen all this in the court. Well, whether he denies it or not, they are matters for record. The court has to go by this. Now, you will see that section 73 is the last section in that group of sections. Though there is a provision empowering the court and enabling the court to compare the signature, superior courts have cautioned the judges it should be last resort. When the execution of a document is seriously in dispute, we can't just go by that comparison and hold that the document is proved or not proved. Wisdom dictates that the court should seek the opinion of the expert. I'll come to that expert evidence a little later. But of course, if there is not so much of a dispute, the stakes are not very high, well, a request would be made to the court to compare the signature apart from other evidence on record. There is one para 3 of section 73. It's a very interesting reading. This section applies also with any necessary modifications to finger impressions. Normally, the court is called upon to compare the signatures, but the section enables the court even to compare the finger impressions. But let us not take the risk of doing it. Comparing the signature itself is a risk, but requesting the court to compare the finger impressions, in my opinion, would not be a proper way of proving a document. It has its own risk, because comparing finger impressions is extremely difficult. Now that I am on the aspect of these finger impressions, an impression which is created in a matter of marking these finger impressions needs to be dispelled first. Because I am on that aspect, let me cover it here also. Objections are raised for marking these thumb impressions, finger impressions during the course of trial. Can such an objection be sustained is the question. The argument that is generally canvassed and accepted also by the court is signatures a person can testify about the signature of another person. But when it comes to finger impressions, he cannot say that it is the finger impression of so and so, and therefore it cannot be marked. It's a very familiar argument which you have heard in the courts and accepted also many times. Let us know the legal position in this regard correctly. I am not imposing myself on you, but I am drawing your attention to statutory provisions and try to tell you that in what situation a finger impression can be marked. If by any chance you have with you the Transfer of Property Act, please go to the definition of the term attested as given in section 3 of the Transfer of Property Act. Section 3 of the Transfer of Property Act, Interpretation Clause. In this act, unless there is something repugnant in the subject or context, attested in relation to an instrument means and shall be deemed always to have meant, attested by 2 or more witnesses, each of whom has seen the executant sign or affix his mark to the instrument, or has seen some other person sign the instrument in the presence and by the direction of the executant, or has received from the executant a personal knowledge of his signature or mark, or of the signature of such person, and each of whom has signed the instrument in the presence of the executed. But it shall not be necessary that more than one of such witnesses shall have it present at the same time, and no particular form of attestation should be necessary. Again, each of attested by 2 or more witnesses, each of whom has seen the executant sign or affix his mark. Please go to section 63C of the Indian Succession Act. 63C of the Indian Succession Act. Execution of unprivileged wills. Every testator not being a soldier enjoy in an expedition or engaged in actual warfare, or an airman so employed or engaged, or a mariner or at sea, shall execute will according to the following rules. A. The testator shall sign or affix his mark to the will, or it shall be signed by some other person in his presence and by his direction. B. The signature or mark of the testator or the signature of the person signing for him shall be so placed that it shall appear that it was intended thereby to give effect to the writing of the will. In our present context, it is class C which is important. The will shall be attested by 2 or more witnesses, each of whom has seen the testator sign or affix his mark to the will, or has seen some other person sign the will in the presence and by the direction of the testator, or has received from the testator a personal acknowledgement of his signature. In fact, a very word found in section 3 of the Transfer of Property Act is to be found in section 63C of the Indian Succession Act. It requires some explanation here. Why we say that a signature can be got marked through a witness? Because we presume that he was present at that time, the executant signed the document in his presence, and therefore he says, yet signed the document in my presence, he executed the document in favor of Y, some transaction took place, I was present, so and so was present, yet put his signature at this place, I saw it, therefore I identify it, exhibit so and so is his signature. That is how the court does it. Now, what does this definition of the word attested and 63C indicate to us? Attesting witness is a person who has seen the executant sign or affix his mark. If the attesting witness says that in his presence the testator or the executant affixed his mark, he is giving direct evidence of it. It is in his presence he does it, he did it. And therefore he says he did it, he affixed his mark in my presence, and therefore I say that it is mark. There is any bar. On the contrary, if it is opinion evidence under section 47, it is impermissible. That is the distinction you should bear. Section 47 of the Evidence Act, to which I will draw your attention sharply, will give us opinion as to handwriting and signature. Well, your senior is dead. You are required to identify a signature found on some wakalat or some written statement, claim some document which he has executed. You are not present when your senior signed it. A witness was not present when his father or mother signed it. He gives opinion evidence. How? Because he is familiar with his signature, being his son, being his daughter, being his brother, being his colleague, being his junior. He gives opinion evidence, though he has not seen it. Suppose if the document was executed in his presence, he gives direct evidence. Now, in the case of thumb marks, direct evidence can be given saying that I saw the executant or the testator affixing this document in my presence. Therefore, I am the firm opinion that LTM also can be marked if the person who says it says that it was done in his presence. But he can't say that in my opinion it is the LTM. That opinion evidence is confined only to section, only to signature as provided by section 47 of the Evidence Act. Now, 73A I am avoiding. Then we have these public documents. Which are those public documents is contained in section 74. All of you know it. Whatever is not stated in section 74 is classified as public documents. 76 says certified copies of public documents can be given. 77 is important. Proof of documents by production of certified copies. Such certified copies will be produced in proof the contents of the public documents are part of the public documents of which they purport to be copies. I see one judicial officer online. I don't want to mention the name of the officer and cause embarrassment to him or her. Both of us had an occasion to work in a particular place near Bengaluru. I as Munsif, she as civil judge in that place. We had a very senior lawyer there by name D.A. Acharya. I have spoken about him on other occasions about his pleadings. In a particular case before me, he had summoned some documents from the office of the commercial tax office. He said, 77 says they are public documents. Public documents can be proved by their production. I have produced it. I don't intend it to mark. The other side, equally an eminent lawyer, he said the court cannot just look into it by marking it. Of course, I must honestly admit I was also not that mature enough to, accept to look into a document not marked. Whatever it is, the purport of this is this. In the case of a private document, the executant may be available to speak about it. The attesting witness may be available to speak about it. If not available, we have seen as to what is to be done. In the case of public documents, can we insist on the author of the document or the scribe of the document to enter into the witness box? The most familiar example is these land revenue records which you produce in the court. They are all public documents. Can we expect the revenue officer every day to come to the court and say that this entry is made by me? This is a copy that I have given. Certified copies of judgments and orders passed by the courts are produced. Can we insist on production of the original? Can we insist on examining the judicial officer who has passed that judgment? Depositions are recorded by the court. Certified copies are produced. Can we call the judicial officer every day and ask him to give evidence that he has recorded that evidence? I jocularly tell, if that is the thing to be done, the judicial officer will end up going to other courts and give evidence that he has recorded evidence, and he will not have time to him to record evidence in his own court. So as far as public documents are concerned, there is no need to examine its author. Provision itself is clear. We have also a decision of 3 judges of the Supreme Court. AR 1963 Supreme Court 1633. AR 1963 Supreme Court 1633. A judgment by a great judge, Justice P.B. Gajendra Gatkar. This is what His Lordship has observed in this statement. Some revenue records and other things. He refers to the view expressed by the trial judge. He was inclined to hold that exhibit A8 have not been proved at all and could not therefore be received in evidence. It has been fairly conceded by Mr. Shastri for the respondent before us that this was plainly erroneous in law. The document in question, being a certified copy of a public document, need not have been proved by calling a witness. Besides, no objection had been raised about the mode of proof, either in the trial court or in the district court. This is with and we have 78. It says proof of other official documents. The following public documents may be proved as follows: acts, order, or notification of the central government or any etc. by the record of the department certified by the head of those departments respectively. Day in and day out, they are produced. Whereas are produced, we read them. Notifications are produced. Proceedings of legislatures, proclamations, orders or regulations, acts of executive or the proceeding of the legislature of a foreign country, proceedings of municipal body, public documents. Now, we shall briefly deal with these presumptions from 79 to 90. As I said, let us not presume what those provisions contain. Let us read them and see. This takes me to the basic definitions in the Indian Evidence Act. May presume, shall presume, and conclusive proof. May presume. See, the words employed, each one of those words has significance. Whenever it is provided by this act that the court may presume a fact, it may either regard such fact as proved unless and until it is disproved, or may call for proof of it. See the employment of different kinds of words in the next section. Shall presume. Whenever it is directed by this act. There, whenever it is provided by this act. Here, whenever it is directed by this act, that the court shall presume a fact, it shall regard such fact as proved unless and until it is disproved. So we say that those facts which the court may presume are discretionary presumptions. The court has got a discretion either to presume or not to presume. But those facts which the court is bound to presume, shall presume, are called mandatory presumptions. The court cannot refuse to presume it. The law itself dictates the court, you shall presume it, and it will be for the other party to disprove it. That is why it says, whenever it is provided. Here, whenever it is directed, the act directs the court to presume it. Then conclusive proof, when one fact is declared by this act to be conclusive proof for another. See the words provided, directed, and declared. We will see which are those sections in the Indian Evidence Act which use the word may, and which are those which use the word shall. I don't expect any lawyer or judicial officer to remember them. I also do not remember it. Maybe because I have been speaking to this for the last several years, I may remember one or two sections. But definitely let us not remember, because we do not know when our memory fails. So therefore, when an occasion arises, let us read them. I jokingly tell, there is no question of application of mind here. There is only question of application of eyes and hands to open the barrack. Application of eyes. There is no need to apply our mind. Language is very simple. 79. The court shall presume to be a genuine every document purporting to be a certificate, certified copy, or other document which is by law declared to be admissible evidence of any particular fact and which purports to be duly certified by any officer. 80. Whenever any document is produced by before any court, purporting to be a record or memorandum of the evidence or any part of the evidence given by a witness in a judicial proceeding, or before any officer authorized by law to take such evidence, or to be a statement or confession by any prisoner or accused person, taken in accordance with law and purported to be signed by any judge or magistrate or by any such officer as aforesaid, the court shall presume that the document is genuine, that any statement as to the circumstances under which it was taken purporting to be made by the person signing it are true. So it's a mandatory presumption. 81 with regard to gazette shall presume. 81A shall presume with regard to gazettes in electronic forms. 82, whenever etc., the court shall presume. 83, court shall presume that maps or plans are accurate. 84, court shall presume the genuineness of every book. 85, court shall presume every document. 85A, presumption as to electronic records. 85B, presumption as to electronic records and signatures. 85C, again electronic signature certificates. 86, presumption as to certified copies of foreign judicial records. So some of these sections use the word may, some of them use the word shall. So as and when an occasion arises, let us read them. I am more concerned with section 90. This is one thing where there is a lot of misconception. Let us carefully read this section 90. presumption as to documents 30 years old. Of course, in the case of electronic records, 90A is inserted. It's only 5 years. Now 30 years. Let us read it very carefully. This does not require anything except understanding the language. If we are comfortable with the English language, if we are able to split the sentences correctly, we will know to what extent the presumption extends. Where any document purporting or proved to be 30 years old is produced from any custody, which the court in the particular case considers proper. So custody must be proper. The document purports to be 30-year-old or proved to be 30-year-old. What is it that the court can do? It may presume, it is not shall presume. I have seen lawyers arguing, it's a 30-year-old document, the court shall presume it. No. It may presume. Court is not obliged to presume. The court may presume what? That the signature and every other part of such document, which purports to be in the handwriting of any particular person, is in that person's handwriting. So the first fact to which this presumption extends is that it is the handwriting of the person by whom it is purported to have been written. Second, and in the case of a document executed or attested, that it was duly executed and attested by the persons by whom it purports to be executed and attested. Therefore, the presumption under section 90, number 1, it is discretionary. The court is not bound to presume a document to be genuine merely because it is 30-year-old. It's a discretionary presumption. Number 2, the presumption is only with regard to handwriting, execution, and signature. It does not extend to content. Where is this confusion is the question. The court may presume that the signature and every other part of such document which purports to be the handwriting of any particular person is in that person's handwriting. It is here the problem arises for most of us. Because I have tried it. In the Judicial Academy, I asked the officers whether the presumption extends to the contents or to what. Some of them read this, every other part of such document. Therefore, the presumption extends to every other part of the document and say that it extends to contents also. It doesn't stop there. Every other part of such document which purports to be in the handwriting of any particular person. Therefore, the presumption is only with regard to handwriting, execution, and attestation. The reason for this is this. 30 years is a long period in a man's life. We are now in the year 2023. There is a document of the year 1990. It is already 30-year-old. The executant may be dead to speak about its execution. The attesting witnesses may be dead or are not available or able to come to the court. The party relying upon it should not be prejudiced because he is not able to prove it. For 30 years, anything might happen. He would be sufficiently old, he would be dead. Then 90 says, in such a situation, the court may presume what? That the executant has signed it. It's a document executed by, purported to have been executed by X in favor of Y. All right, the court may presume, because we also know at an undisputed point of time it has come. The court may also presume that Y, A and B have attested it. The presumption only extends to this. Now, if we extend the presumption to the contents, section doesn't say that it extends to the contents. See the consequences of it. Now, there is a document said to have been executed by X in favor of Y. Y relies upon that document. X is dead, or X denies its execution. The attesting witnesses are dead. Well, to prove the signature and other things, certainly that presumption can be drawn. Supposing X has executed a document in respect of a property which does not belong to him at all. Can we say, well, this document is executed Section 90 says to presume everything. Can you say that the transaction is also genuine? That Y has become the owner of the property because of this presumption under 90. Somebody may execute a document without any title. Therefore, the question of extending the presumption under section 90 to the contents does not arise. Let us be very clear about this. Now, there are a few more issues in this regard. How this 30 years has to be calculated? Obviously, the starting point is the date of the document, which is the end point. It is not the date of suit. It is not the date of written statement. It is not the date on which the document is produced under Order 7, Rule 14 or under Order 8, Rule 1A. The reason is obvious. Now, let us say we have a document of the year 1990. The suit is filed in the year 2019. In the year in which the suit was filed, the document was only 29-year-old. It was not 30-year-old. Are we recording? Did we record evidence in the year 2019 when on the very day the suit was filed, or in the very year in which the suit was filed? The matter has come up for evidence today in the year 2023. By now it has become 30-year-old. The persons intimately connected with the document, namely the executant, attestors, are dead. Therefore, the date on which the document is tendered in evidence is the outer limit. It is not the date of suit. It is not the date of written statement. It is not the date of production. Additional documents are produced under 7 Rule 14 or under Art 8 Rule 1A. The outer limit is the date of tendering it in evidence. The starting point is obviously the date of the document. Our starting point is from this decision. (2013) 9 SCC 319. 2013 9 SCC 319. 2015 4 SCC 601. In both these decisions, it has been held that 30 years commences from the date of execution of the document, and it lasts on the date the document is tendered in evidence. The next question, which again the statute doesn't provide us a guidance, we will have to necessarily go by decisions, whether the presumption under section 90 of the Evidence Act extends to a copy also. We will begin our journey from Privy Council. AER 1929 Privy Council 115. I will first give the list of decisions. Thereafter, I will tell you what the ratio is. AER 1929 Privy Council 115. AER 1935 Privy Council 132. AER 1935 Privy Council 132. 1996 8 SCC 357. 1996 8 SCC 357. In these decisions, it has been held that a foundation is laid for letting in secondary evidence as provided in section 65 of the Evidence Act. And when secondary evidence is let in and copy is marked, presumption also can be drawn under section 90, provided that secondary evidence is itself 30-year-old. That is the view taken by the Supreme Court. That secondary evidence or the copy which we rely upon should itself be 30-year-old. If it is a recent document, the presumption cannot extend under section 90 is the view taken. Then, can this presumption be extended in the case of a will? The Supreme Court has held that will requires special considerations. Presumption under section 90 cannot be raised in case of a will. That is 2009 3 SCC 687. 2009 3 SCC 687. 2013 7 SCC 490. 2013 7 SCC 490. for the benefit of those practicing in Karnataka and working in Karnataka, a decision of the Karnataka High Court also may be referred to. That is ILR 2007 Karnataka 4254. This decision relies upon the first statement of the Supreme Court I have cited. It is ILR 2017 Karnataka 254. Well, in one case, the Honorable High Court raises the presumption under Section 90 in a different circumstance. I don't want to trouble the audience with the decision. So let us be very clear about this. The presumption under Section 90 is a discretionary presumption. It is not a mandatory presumption, as is clear from the employment of the word may and not shall. Presumption extends only to handwriting, execution, and attestation, and not to its contents. 30 years, it starts from the date of execution and ends with the date on which the document is tendered in evidence, not the date of the suit, not the date of the written statement, not the date of its production under 7 Rule 14 or under Order 8 Rule 1A, when it is actually tendered in evidence. Presumption extends to copy also, provided sufficient foundation is laid under Section 65 for letting in secondary evidence, and the copy itself is 30-year-old. Lastly, in the case of a will, the presumption doesn't extend under Section 90. Now, I thought of dealing with sections 91 to 99. I think I may not have time to do that. Let me see at the end if time permits. I have other things to tell you. Now we have seen how a document which requires attestation requires to be proved, examining one attesting witness if it is available, alive, etc. If not available, by any other evidence. The provision says by any other means, by any other mode, what that mode is not provided. Well, what are those modes? One, by recourse to Section 47. Yes. All right, let me go in an order. We have a group of sections in the Evidence Act with the title Opinions of Third Persons when Relevant, commencing from Section 41 and ending with 51. For today's purpose, only Section 45 and 47 would be relevant. Expert evidence is opinion evidence under Section 45 of the Evidence Act. When the court has to form an opinion upon a point of foreign law or of science or of art or as to the identity of handwriting, the opinions upon that person's point of person specially skilled in such foreign law, science or art are in questions as to the identity of handwriting or finger impressions or relevant fact. Such persons are called experts. Well, the legal position in this regard is very clear. The expert's evidence is only opinion evidence. It does not bind the court. But the court has to give valid reasons as to why it is not accepting the opinion of the expert. If the court comes to the conclusion that the expert has not followed the procedure, he is himself, the person who has given that opinion cannot be called to be an expert. There are situations where we reject it. But expert opinion is only opinion. It does not bind the court. You will find where that Section 45 is found. It is in the group section dealing with relevance of facts, commencing from Section 5 and ending with 55. So, opinion of expert is also a relevant fact. It is not. Just as any other relevant fact is a piece of evidence the court considers in arriving at a decision, be it a civil case or a criminal case. Similarly, the opinion of expert is also a relevant fact. It is not conclusive. It does not bind the court. This is the first principle. The second principle is, if there is a conflict between opinion evidence and direct evidence, that is the evidence given before the court, it is the direct evidence which prevails. Let us be clear about these fundamentals. There are decisions. We don't have time to refer to all of them, but these are all well settled propositions. I'll give an example. We will see. We will take the case of any document for that matter, more particularly a document which requires attestation. The execution of it is in dispute. Now, an attesting witness is examined by the person. Let us take it as plaintiff. Plaintiff relies upon a gift deed, the execution of which is in dispute. He examines the attesting witness, one of the attesting witnesses. There is nothing in the cross-examination for the court to disbelieve. The opponent lawyer also finds, well, despite my serious cross-examination, I have not been able to create a dent in his evidence. It is a little risky for me to leave the matters at that stage. Let me not run that risk. He may advise his client to have the expert opinion. He may move the court under Order 26 Rule 10A CPC for sending the document to a handwriting expert. Now, the opinion of the expert is in favor of the defendant. The evidence of the attesting witness is in favor of the plaintiff. The opinion of the handwriting expert is in favor of the defendant. Obviously, the defendant lawyer would argue, well, I have this opinion evidence. The expert has given this. After all, he is an attesting witness. The opinion of the expert is in my favor. The court has to rely upon it. Junior lawyer appears for the plaintiff. He is also frightened. Well, the legal position is very clear. If there is a conflict between direct evidence and opinion evidence, it is the direct evidence which prevails. It may sound a little strange for the novice in the field. After all, he is an expert. The court is not relying upon the expert evidence, relying upon the evidence of a person who has given evidence before the court. That is the majesty of the judicial system. We give importance to the evidence of a person who enters the witness box. He is cross-examined, his veracity is tested, his credibility is tested, attempts are made at impeaching him, all that. Therefore, if he withstands the test of cross-examination, wise people in the field have told us that the court has to give credence to his evidence. So if there is a conflict between opinion evidence, that is the expert's evidence, and the direct evidence of this witness, direct evidence, don't think that it is only the case of a criminal case. In a civil case also, there could be direct evidence. What is the direct evidence? In my presence, the plaintiff or the defendant executed this document. This is his signature. So therefore, if there is a conflict between expert evidence and direct evidence, it is the direct evidence which prevails. This is one thing which we shall bear in mind. The next question is whether this expert should be examined by the court, by the party relying on it too, and should that be marked? Kindly have a look at Order 26 Rule 10A. The Evidence Act doesn't refer to it. Evidence Act only says what is relevant and how it is to be proved. But can it be made use of by the court without marking it and without examining the expert? Please go to Order 26 Rule 10A. Rule 10A is an insertion made when CPC was amended in 1976. Well, lawyers make application under Section 45 of the Evidence Act. Some make it under Order 26 Rule 10A. Some refer to both the provisions. Some do not like to take any risk. They know the inherent powers of the court under 151, for whatever reason it be. Power exists in the court to send a document to an expert. A right exists in a party to seek the opinion expert. We will go to Rule 10A. Where any question arising in a suit involves any scientific investigation, which cannot, in the opinion of the court, be conveniently conducted before the court may, if it thinks it necessary or expedient in the interest of justice so to do, issue a commission to such person as it thinks fit, directing him to inquire into such question and report thereon to the court. Subrule 2 is important. The provisions of Rule 10 of this order shall, as far as may be, apply in relation to a commissioner appointed under this rule, as they apply in relation to a commissioner appointed under Rule 9. Rule 9 is invoked for appointment of a commissioner for local investigation. Rule 9, all of us know it. Rule 10 is the procedure of commissioner appointed under Rule 9. The commissioner, after such local investigation as he deems necessary, and after reducing to writing the evidence taken by him, shall return such evidence together with his report in writing signed by him to the court. Sub-rule 2 is important. Report and depositions to be evidence in suit. The report of the commissioner and the evidence taken by him, but not the evidence without the report, shall be evidence in the suit and shall form part of the record. Therefore, as we said, Article 26, Rule 10A, Sub-rule 2 says, the provisions of Rule 10 with regard to local investigation apply to a commissioner appointed in the Rule 10A, there is an expert. Rule 10, Sub-rule 2 says, the report of the commissioner and the evidence taken by him, but not the evidence without the report, shall form part of the record. When it forms part of the record, it need not be marked, the expert need not be examined. But it is an enabling provision, but the court, or with the permission of the court, any of the parties to the suit may examine the commissioner personally in open court. If the court thinks some clarification is required from the expert, certainly the court can suo motu summon him, or any party can summon him. Any of the matters referred to him are mentioned in his report, or as to his report, or as to the manner in which he has made the investigation. Now, the practical aspect of this. Let us say the report of an expert is in favor of the plaintiff in a given case. A defendant files objections. A lawyer who knows the correct legal position will not take the risk of examining the commissioner expert on his own. Why should he? He has read Article 26, Rule 10A. He knows the legal position. He says, I need not mark it, I need not examine. The court can look into it, it is a part of the record. He doesn't want to do it. Well, the defendant lawyer argues at the time of argument saying, well, I have filed objections to the report. The court cannot look into it. No. If you file objections, pursue it. Article 26, Rule 10, Sub-rule 2 enables you to summon him. Now the problem arises. The plaintiff doesn't want to do it because the report in his favor. Why will he take the risk of putting him and getting all adverse answers? The court also doesn't want any clarification. It doesn't do it. Now the defendant summons him. Here the problem arises. When the defendant summons him, well, he will be the defendant's witness. The Evidence Act says that you can't examine your own witness by putting leading questions. The practical way of doing it is this. Put a few formal questions in chief examination. Are you the expert appointed in this case? Is it the warrant issued? Are these the papers given to you for comparison? Have you submitted a report? Get them marked. Then a request may be made to the court. The report of the expert is against me. I may be permitted to cross-examine him, otherwise I can't elicit the truth. As I said, 154 of the Evidence Act enables it. That can also be done. Or the court may summon him. The court may examine him as court's witness. The court may formally mark the report and other papers as exhibits C1 and other things. Then the defendant lawyer may seek the permission of the court to cross-examine him. So that, therefore, that should not be a big problem in that regard. Then we will go to section 47. You will find section 47 is also in the same group of sections under the head opinions of third persons. 47. Opinion as to handwriting when relevant. When the court has to form an opinion as to the person by whom any document was written or signed, the opinion of any person acquainted with the handwriting of the person by whom it is supposed to be written or signed, or that it was or was not written or signed by that person is a relevant fact. As I said, the son or daughter of a person is familiar with his father's signature or mother's signature or her mother's or father's signature. A colleague is familiar. A junior is familiar. A subordinate is familiar with the signature of his official superior. That document might not have been signed in his presence, but he is familiar with his signature in the usual course of business. Then what is that explanation? A person is said to be acquainted with the handwriting of another person when he has seen that person write. See, the document in question might not have been written in his presence. That will be a case where he gives direct evidence. But on some other occasions, I have seen my father writing, I have seen my son writing, I have seen my senior writing. I am familiar with his writing. Therefore, in respect of this disputed document, though I was not present when he wrote it, though I was not present when he signed it, I give opinion evidence saying that it is in his writing, it bears his signature. I think this is how we'll have to understand it. A person is said to be acquainted with the handwriting of another person when he has seen that person write. He has actually seen that person, not the document in question. He has seen that person writing some other document. Therefore, he is acquainted with his handwriting. Or when he had received documents purporting to be written by that person in answer to documents written by himself or under his authority. I have written a letter to my brother. In reply to it, he writes it. I have been writing it. He gives me reply. Therefore, I know it is. I was not present when my brother wrote the reply. He has just posted it. But I am familiar with it because over a course of time, I have been writing to him. He has been writing to me. And addressed to that person, or when in the ordinary course of business, documents purporting to be written by that person have been habitually submitted to him. Well, the staff make a note saying, we are familiar with the signature of our staff, we are familiar with the signature of our official superiors. So this is opinion evidence with regard to section 47. Now, one care which both the judicial officers and the lawyers need to take with regard to the evidence of the attesting witness is this. The problem with the men of my generation is only this. Because we started our career before CPC came to be amended. Examination in chief used to be recorded in the court. So whenever a document was marked, we were asking the plaintiff or the defendant, is this the document? And you said that you have produced the document. Is this the document which the opponent has executed? What has he done for this? He has signed. Exhibit so and so is the document executed by the defendant. P2A is his signature. Who are all present at that time? Some X and Y were present as attesting witnesses. P2B is the signature of attesting witness number 1. P2C is the signature of attesting witness number 2. Then the attesting witness would come and he would say, I was present when the defendant executed the document in his presence. Exhibit P2 already marked is the document. The signature of the defendant is at exhibit P2A. P2B, which is already marked, is my signature. Defendant signed that document in my presence. What I have seen as a judicial officer after CPC came to be amended, and of course I retired 7 years back, I do not know whether the same position continues. Hope things have improved. If not improved, let us be very clear. What I have found is this. An affidavit is filed of the attesting witness. He says everything in tune with section 63 of the Evidence Act, Indian Succession Act, everything. The will was executed in my presence. Even there was of sound disposing state of mind, this document. And the lawyer does not get identified the signature of the testator or the executed. There is only an affidavit saying that he signed in my presence or affixed his mark. That is not got marked at all. It might have been got marked through plaintiff, but who is the person? What is the role of the attesting witness? He has to say that the document was executed in his presence and the testator or the executant affixed his signature or mark in his presence. That is not elicited, and he should show to that document. You say that he affixed his signature there. Well, if it is already marked also, you may have to show it to him saying that the signature is already marked, is the signature of that person. This is a care which the lawyers will have to take, and if some young lawyer not knowing the legal position or a senior lawyer who has forgotten the legal position were to conduct the cases in this manner, judicial officers should be a little active, and because ultimately they write the judgment, they will have to get it elicited from the witness. This is one other thing. Then I spoke to you about the presumptions under the special enactments, because there are two parts in my presentation. One is the proof of documents and their importance in civil cases? Well, in civil cases, documents generally assume more importance because parties base their case on documents. We give preference to documents if duly proved as provided in these various provisions. We extend presumptions available under section 79 to 90 in given cases. When there are statutory presumptions, mandatory presumptions, we are bound to apply them. There are discretionary presumptions. Experience will tell us when we should exercise the discretion, how we should exercise the discretion. Apart from the presumptions contained in the Evidence Act, we have also presumptions under the special enactments. For example, the Negotiable Instruments Act. Lawyers of this generation know only section 139 of the Evidence Act, the Negotiable Instruments Act, which provides for presumption if the accused is prosecuted for an offence under 138. But there is another section in the Evidence Act, that is 118. 118 of the Evidence Act contains a list of presumptions. They are all mandatory presumptions which the court is bound to draw. One such presumption is very important. Every negotiable instrument is presumed to have been drawn for consideration. Eminent lawyers of yesteryears and good judicial officers of yesteryears were very rightly framing issues. Lawyers also were assisting them. If it is a suit based on a promissory note, all that the plaintiff was required to prove, will be required to prove is that the defendant executed it. He is not required to prove passing to the consideration. Proving a negative, the burden is cast on the defendant because there is a presumption under 180 that every negotiable instrument is presumed to have been drawn for consideration. The first issue those learned judicial officers of yesteryears were framing was whether the plaintiff proves the execution of the suit on demand promissory note. Second issue, if so, does the defendant prove that it is not supported by consideration? Even in the case of a check, because it's also a negotiable instrument, whether the plaintiff proves that the defendant has issued this check. If so, does the defendant prove that it is not supported? The plaintiff is not expected to take both the burdens. Plaintiff, the issues that are no framed is whether the plaintiff proves that the defendant borrowed 20 lakhs and executed the suit pro not. No. Plaintiff need to prove only the execution of the document. Burden shifts to the defendant. Then we have presumptions under the land revenue laws. Of course, I am from Karnataka. I know the presumptions under the Karnataka Land Revenue Act. An entry in a revenue record is presumed to be genuine unless it is rebutted, and it should be a lawful entry. The name of the plaintiff is found for 20 years or his ancestors' names are found. Suddenly, the name of the defendant finds in the relevant column of the Pahani. No. The defendant should explain how his name came to be entered. Then only the presumption under the relevant section of the Karnataka Land Revenue Act. There may be similar provisions under the other state enactments also. Then we have presumptions under the Hindu law. What is that presumption? A property continues to be joint. It is for the person who says that there is already a partition to prove it. We have the Benami Transactions Prohibition Act of 1988 also, which says if a property is purchased by a man in the name of his wife or unmarried daughter, it shall be presumed that it is for her benefit. I am not finding a similar provision in the new enactment. It may be there. So these are certain presumptions which we should be aware when we address arguments before a court and when we as judges write judgments in a civil case. So as I said, importance of documentary evidence in a civil case is this. We generally go by this. Oral evidence would be relevant in cases where a plea of perfection of title by adverse possession, either by the plaintiff or by the defendant, is taken. We now know that the Honorable Supreme Court has also said plaintiff also can seek title based on adverse possession. Obviously, when the plea is based on adverse possession, there will be no question of documentary evidence. Continuous possession for over 12 years with that required animus requires to be established. In the matter of interference with possession, oral evidence, and the decisions are if the defendant denies the plaintiff's possession and title, that itself can be taken as interference if the plaintiff is able to prove his possession. I had on some other occasions spoken about evidence in the case of these partition matters. Well, in the case of partition matters, if there is a written document, nothing like that. Otherwise, oral evidence, some person who was actually present when the partition took place will have to be examined. No purpose is served by examining the LRs of the defendant who are just 20 years old, 16 years old when the partition took place. So, importance of documentary evidence is this. Of course, sections 91 to 99 are also connected with this. We have no time because there is exclusion of oral evidence by documentary evidence. On some other occasion, at the convenience of Mr. Vikas Chatrat and my convenience, we will deal with 91 to 99 on some other occasion. I think that this should be sufficient for the day. Any questions? Not in respect of any pending matters by advocates, please.
It is always a pleasure to hear. As they say that it sounds to any student of law, maybe even a judicial officer, it is just like music to his ears. And the wide range of topic you have taken, it's quite fascinating. I'll take few questions. We will not take these are questions which are of persons where the matters are sub judice.
Yes.
To prove a notice is sent to defendant before filing of the suit, how can it be marked since original is with the defendant and they are denying the receipt of the notice? This is by Nitin Kaskar.
Please go to section 66 of the Evidence Act. 65 cases in which secondary evidence related to documents is given when the original is shown or appears to be in the possession. B, when the existence condition. When the original has been destroyed or lost. D, when the original is of such a nature. E, when the original is a public document. F, when the original is a document. Now let us go to section 66. Secondary evidence of the contents of the documents referred to in section 65 clause A, that is when the original is in the possession of the defendant, shall not be given unless the party proposing to give such secondary evidence has previously given to the party in whose possession or power the document is, or his attorney or pleader, such notice to produce it as is provided by law, and if no notice is prescribed by law, then such notice is the court considers reasonable under circumstances. Provided that such notice shall not be required in order to render secondary evidence admissible in any of the following cases or in any other case in which the court thinks fit to dispense with it. When the document to be proved is itself a notice, plaintiff has sent a notice to the defendant. Plaintiff has only a copy of it. Defendant is presumed to have the original. Now the defendant denies it. There is no need to issue notice under section 66 because the document to be proved is itself a notice. No notice for the plaintiff to issue a notice to produce the original because the defendant has denied it in the written state. Yes.
The next question is if the document.
Of course, the plaintiff will also produce the postal receipt for the evidence in dispatch of the notice. And if it is served on the defendant, that acknowledgement, and that will be proof that the notice is served. Yes.
So next question normally arises is that let's assume somebody has sent a letter by post and that too by an envelope. How do you prove the contents?
That too. I didn't hear you.
So sent through a registered post in an envelope.
Yes.
Like a normal letter. How do you prove what was written in the contents? Because sometimes it's a plain page which has been sent. How do you prove that what was sent?
The usual presumption is that it is not an empty envelope that is sent. The presumption is that it really contained some letter or document. Now, if that is returned, the defendant has refused to receive it, or it is returned for want of correct address, or he was not present when the letter was taken by the postman to the address, it is returned. Open it, find out whether it is there. If it is not there, obviously the plaintiff has sent a blank envelope.
No, the question is you have sent something, but the contents are actually what you are trying to show is different. Then that's
how does that happen? How does the defendant show that what was sent is something else? He must have received it. If he has received something other than what I have said, well, he must produce it. He must produce it along with the cover.
No, sometimes sometimes the lawyers also send a blank pages, so it's very difficult. So how do you come out of that?
Let the defendant produce it immediately, the blank pages. The moment he files a written statement, let him produce it.
And so the next question is by Ashok. He says, if the document is registered sale deed and is more than 30 years old, how can it be proved in court?
The question is this. In the case of a sale deed, first of all, attestation is not required. Now it is a 30-year-old document. The court may presume that it has been executed by the person by whom it purports to have executed it, and it is also a registered document. Well, it may be a fit case where the court can be persuaded to raise the presumption under Section 9. And other evidence, the original is with him. He may ask the court to compare the signature of the executant on the original with the other available signatures. He may also take the specimen signatures before the court. The court may be asked to compare the specimen signatures before the court. If the stakes are very high, well, we may also seek the opinion of the expert. If attesting witness is available, nothing beyond that. Though sale deed doesn't require attestation, if he is available, best evidence would be that.
Your 3 A's will come into being.
Yes.
Your 3 A's will come into being. Alive, availability, and able person.
Yes.
This is Chandrasekhar, a public document obtained under the RTI. Can it be marked or?
Yes. Right now, I'll have to get the RTI Act. It is here. Under the RTI Act, it will be a public document that can be certainly be produced. It would be a public document covered by the provisions of the Evidence Act. Under Section 77, it can be marked. Right now, I am not able to give you the relevant section under the RTI Act. It is a public document, and I am given to understand that the Madhya Pradesh High Court has taken a similar view. AR 2015 Madhya Pradesh 186. AR 2015 Madhya Pradesh 186. Narayan Singh versus Kallaram. Documents obtained under RTI Act constitute valid secondary evidence within the meaning of Section 65. Of course, I will have to read that decision, but anyway, I am safely relying upon it because I am confident about the source from which I have received it, and therefore I will safely rely upon it and say that that is the ratio laid down under the act, under that in the decision.
This is Nitin. Contents are proved by production of original. Do we really require to prove the contents in terms of Section 90 presumption?
No, Section 90 doesn't provide for presumption regarding contents at all. It only provides a presumption in the matter of signature, handwriting, and attestation. Contents have to be proved in the usual course. Well, this is one thing. When the document is proved, when the document is, of course, marking is one thing, proof is another thing. They're all basic things. Now, when the execution of the document is disputed, and when it is proved in a manner known to the Evidence Act, the document is available on record, the executant's signature is proved, executant's mark is proved, everything is proved. Nothing bars the court from looking into the contents. If the contents are something which the other side disputes, well, to what extent he could dispute is covered by sections 93 to 99 of the Evidence Act and the provisos to sections 92, about which I think somebody has already spoken on your platform. If need be, we will speak on a different occasion.
Like we always say that everyone with the same products, everybody, the chef makes it differently. So we'll take a session from you also.
Okay.
And this is by Rakesh. If a notice is sent to produce a document as returned to the addressee left, can secondary evidence be admitted?
See, actually, the practice that we had when we were lawyers and what we have seen in the court is notice under Section 66 of the Evidence Act is not sent generally outside the court. It is to the court under Order 12. The provisions of Order 12 are invoked, calling upon the other side to produce a document. So therefore, normally a notice outside the court, I have not seen a case where notice under Section 66 is issued outside the court. It is to the medium of the court when the matter has reached the court, to the medium of the court, notice is taken. That is why Section 66, it says in the manner prescribed, that is under Order 12.
So the last question, somebody has just sent a test. Is there any difference between an opinion evidence and an expert evidence?
Expert evidence is one kind of opinion evidence. Section 45 deals with opinion evidence of experts. Section 47 deals with opinion evidence given by persons appointed with signature and handwriting. 48 deals with opinion evidence regarding the right or custom. 49 gives opinion evidence regarding tenants. 50 gives opinion regarding relationship. So and so is my son, so and so is my mother. You will say that so and so is the son of so and so, because you have seen that person introducing him as his son, as his wife, as his daughter. You form an opinion. Nobody can be present when a person is born, or we cannot be present in all weddings. But people have conducted themselves as spouse, as husband and wife. We go to a friend's house, my friend tells he is my father, he is my wife, she is my wife, he is my son. I am specially appointed. That's what section 50 says. When the court has to form an opinion as to the relationship of one person to another, the opinion expressed by conduct as to the existence of such relationship, or any person who as a member of the family or otherwise has special means of knowledge. As a member of the family, someone tells aunt, well, she may come and say, well, he is the son of so and so. Or a close friend, or a well-wisher, who has a special means of knowledge, can also give that evidence. See, the framers of the Evidence Act, of course, barring a few sections where they did not commit themselves to any particular situation, because they believed in the wisdom of the lawyers and judges, every contingency is almost met. What we have seen is only an addition to certain provisions of the Evidence Act, like A, 45A, 90A, B, 80P, and all that. We don't find any amendment to, right? We see number of amendments to recent enactments, but as far as the Evidence Act, the Contract Act, the TP Act is concerned, we hardly find any amendment. That is the precision with which the enactments were drafted. The only thing is we should have some minimum command over the English language to understand those provisions. That's all. Or if there is a good translation in the local languages, we can rely upon it.
Arpita, whether subscribe can be examined instead of the attesting witness to prove the
Well, scribe can be examined in the place of the attesting witness, provided the scribe has affixed his signature with an intention to be an attesting witness also. In fact, I did not want to give the decision of the Karnataka High Court on that point. Now that she has asked that, I will advise her to read this decision in RSA 861 of 2016. RSA 861 of 2016. Date of judgment 15/6/2017. 15/6/2017. Vasant Bhasme versus Shankarrao Bhimrao Bhasme. It's also directed to be reported. And every time I say it is directed to be reported, and I have not myself found out where exactly the decision is, and it is reported. This explains this legal position. If the scribe has attested the document with an animus of being an attesting witness also, well, that would be a rare situation. See, what happened in that case was a very peculiar situation. The scribe was dead, the attesting witnesses were dead. And deliberately, I did not cite the decision because I don't know the legal, position taken by other high courts. As far as Karnataka High Court is concerned, we have very beautiful judgment there. That is a case where the scribe was dead, the attesting witnesses were dead. The counsel, relying upon that will, examined the son of the scribe, who also happened to be a professional scribe. The counsel elicited from him in the chief examination that his father was in the habit of attesting the documents which he was scribing. He was in that habit. That portion of his evidence in the chief examination was not challenged. Therefore, the Honorable High Court said this is a case where the scribe had signed not only as a scribe but also as an attesting witness. Of course, some more details are given in that regard. And with regard to that aspect of the matter, well, in a different context, the same Honorable Judge has written one other judgment with regard to the proof of will, which also be, because endorsements made by the registrar at the time of registration, that can also be read by the officer. That is in RSA 1301 of 2009, 1301 of 2005, RSA 1301 of 2005, Tallava Virupachappa Banakar versus Bhadavva. Date of judgment is 22/8/2017. His Lordship has referred to Section 68, 69, 89, and 90 of the Evidence Act, 58 to 60 of the Registration Act, proof of will, when secondary evidence can be given in respect of will. All those things have been beautifully explained. That would be referred to. Yes, any other question?
This is where oral and documentary evidence both are available on the same fact. What is the position of appreciation?
Documentary evidence prevails. Unless the oral evidence is so strong as to completely outweigh the documentary evidence. Because in the context of a civil case, I am speaking today. In the case of a criminal case, obviously we go by the oral evidence, except in the case of Mahariyas. Criminal law says that nothing is substantive evidence.
The last question is, whenever a notice is sent for a check bounce, accused takes the stand he did not receive the notice.
Accused.
Although the RAPD is successful, how the complainant can prove that the contents when accused refuses by a secondary evidence?
Well, right now I am not able to give you the exact decision. I think the Justice K.T. Thomas long back said in a case under Section 138 of the NI Act, if notice is sent to the last known correct address and if it is returned, the court can presume that the notice was sent to the correct address. Right now I am not able to give you the citation because I have not updated myself about the decisions in the matter of Section 138 of the NI Act, because there are better persons to speak about it. And I usually, and recently I have been telling that our Judicial Academy is like a multi-speciality hospital where there are persons specialists to speak on each subject. Somehow, since there are others who speak about 138, I have not troubled myself in updating the legal position. There are basics I know, but recent developments there are many. But I am sure that the decision of K.T. Thomas to that proposition still holds the field, subject to correction.
Yes, sir. So it was a really informative session, and we actually thoroughly enjoyed the session. And we will stay connected. We will take short topics also, and it's always a pleasure hearing, sir. Thank you, everyone. Stay safe. Stay well. Thank you.